Morning.
Good morning.
Welcome, everybody. Welcome, everybody. My name is Tim Lindsay, and I am Director of the Centre for Indonesian Law, Islam and Society at the University of Melbourne's Law School. I begin by acknowledging the Wurundjeri peoples of the Kulin Nations as the traditional owners of the land on which our law school stands, and also the Bunurong people on whose land I am located today. We pay our respects to their elders, both past, present, and emerging. Let me begin by again welcoming all participants, speakers, and audience. There are about 350 of you who have registered, and I know more will be following us on YouTube, where this seminar is mirrored. So to all of you, many thanks for joining us today. However, I do need to ask you all to please mute your microphone, switch off your microphone and switch off your video. We are using a lot of bandwidth today, so only the people actually presenting should have their microphones and cameras on. Thank you very much. Today, we're lucky to have a range of Indonesian and Australian scholars joining us, some established, some emerging, to discuss criminal law in Indonesia, a subject that is sometimes overlooked in contemporary scholarship. As I think you'll all know, Indonesia's criminal law system today faces major challenges. Despite the country's transition to democracy, both the Criminal Code and the Criminal Procedure Code are badly out of date. The former only slightly changed since colonial times, and the latter, the Procedure Code, remaining as it was under Suharto's authoritarian New Order regime. But there are other serious problems too. There are, of course, honest law enforcement officers and judges in Indonesia, but many are widely seen as corrupt or incompetent. Likewise, new laws, including new Sharia laws passed at the regional level, often contradict the criminal code and national statutes, including human rights law. What's more, Indonesia still struggles to bring its criminal law into line with international standards, including even many treaties it has ratified. And of course, the correction system is clearly in trouble, with overcrowding reaching crisis point. These are some of the themes we will discuss today, with a focus on recent efforts at reform and prospects for success. And these themes are all covered in this book, Crime and Punishment in Indonesia, which Dr. Helen Pausaka and I edited, and which will be launched later on in this seminar by Dr. Todung Mulya Lubis. But for now, I'd like to show you a short video summarizing the chapters in this book, because most of these chapters will be presented today in our seminar by the authors themselves. And once we've seen this video, I'll hand over to the other editor of the book, Helen Pausaka, and she will make some more remarks. So once again, to all of you, thank you very much for joining us today. It's going to be a very exciting event. Terima kasih.
Hello and welcome to everyone, and thank you very much to Lilith for compiling the video that we've just seen. So I'd like to offer a few thanks before we start on the seminar and also the book launch. I'm Helen Pausaka, the other editor of the book. So first, I'd like to thank all of the contributors who we made write these chapters and sent back and forth doing multiple drafts. So thank you all very much for your patience. We'd like to thank the publisher, Peter Sowden, and all the staff at Routledge who helped in the publishing of the book. We'd also like to thank the sponsor groups who sponsored this webinar and launch. SILIS, the Centre for Indonesian Law, Islam and Society, LIPI, the Research Centre for Society and Culture, the Jentera School of Law, LEIP, the Indonesian Institute for Independent Judiciary, and Hukum Online. We'd also particularly like to thank Lilis Mulyani, Rifki Asagaf, and Josie Katarina, who have worked with us on this webinar and launch. And in fact, it was Lilis's idea. We'd also like at this point to thank Catherine Taylor and Debbie Yu, who've done all the hard working for organising the webinar and the launch. And thank you very much to everybody for attending. And we're very excited to have you here. While we like seeing you, we would ask that everybody turns off their microphones and their videos to enable us to have enough bandwidth for this. Thank you. And I'll hand over now to Lilith, I think, yes.
Thank you very much, Helen. Terima kasih. Assalamualaikum. Good morning, everyone. I hope you are all well and happy. And welcome to this workshop and book launch this morning. Saya ingin mengingatkan kembali buat peserta, kami minta tolong karena ada isu di bandwidth. Mohon semua peserta untuk mematikan video dan memute atau mematikan mikrofon. Dan hanya presenter saja yang bisa menyalakan video dan mikrofonnya. Nanti akan ada sesi pertanyaan dan diskusi di mana para peserta bisa menyalakan videonya. Terima kasih sebelumnya. First, I would like to introduce myself. I think, as Helen has already mentioned, my name is Lilis Mulyani. I am from the Indonesian Institute of Science. I will be responsible for hosting the first 3 panels this morning. I also would like to thank CILIS, the Indonesian Center for Indonesian Law, Islam and Society at the Melbourne Law School. I also would like to thank the Indonesian Institute of Science, my institutes, Jentera Law School in Jakarta, the Indonesian Institute for Independent Judiciary and Hukum Online, and those people from those institutions that have helped us in preparing this today's event. Before we begin, I actually remember that we joined this book publication workshop in 2017 at Melbourne Law School. It was an eye-opening moment for us as we discussed the challenge and the future of Indonesian criminal law and criminal justice system. We were proud and extremely happy to finally able to see those discussions in book, thanks to Routledge Publishing. And we are also happy to be able to discuss this book here in today's event with everyone. As for these panels, these first panels the panels in this discussion actually represents the themes written in the books, in which the authors or presenters are also contributors to the book. This book has a quite long journey from 2017. And we finally able to present that here to audience, whether in Australia, in Indonesia, and also everywhere in the world. The first panel is about the criminal law codes. Originally, we have 3 chapters in this theme, The first and second chapters is written by Professor Simon Butt and Professor Tim Lindsay. Professor Simon is from the University of Sydney and Professor Tim is from the University of Melbourne. There are also the third writer, which is Dr. Ken Setiawan, who write the third chapter, but we regret that she cannot make it to be with us today. But her work can be read in the book. I would like to first introduce our first speaker, Professor Simon Butt. He is a professor of Indonesian law. He is also the Associate Director in Indonesian Studies at the Center for Asian and Pacific Law at the University of Sydney in Australia. He teaches and researches in Indonesian law, which is made Simon very fluent in Bahasa Indonesia. His doctoral thesis was on Indonesian Constitutional Court, and among his publications is Indonesian law, which is also written with Pak Tim Lindsay in 2018. Once again, I would like to remind the audience that you can post a question or chat in the column, in the chat column here in the Zoom meeting. We will collect and hopefully we'll be able to read them all during the question and answer session later on today. And we would also like to please everyone to turn off their video and turn their microphone off, except for the presenter that will present for today's session. So without further delay, I would like to invite Professor Simon Butt to share with us his and Pak Tim's chapter on the book, which is about the criminal code and criminal procedure code. Simon, the time is yours. Simon.
To speak at this launch. I very much enjoyed working on the chapter with Professor Lindsay, with Prof Tim, and also on the chapter I wrote about the Aceh judicial review case. Great to see some of my co-authors, even virtually, in this coming to Indonesia. This is as good as it will be, I think, for a couple of years for Australians who want to visit Indonesia. But it's great to see so many friends and smiling faces from Indonesia and Australia. So Tim and Helen have asked me to talk a bit about the first two chapters of the substantive parts of the book on the criminal code and the code of criminal procedure. Now, I think I may be preaching to the converted in this forum, but I think it's fair to say that most of us would agree that the two codes are very outdated and are ready for the tong sampah. As you'll know, the criminal code itself is essentially the code the Dutch enacted in Indonesia in 1918, as Tim mentioned earlier. It was applied until independence and then adopted by the Indonesian government, which over the ensuing 75 years or so has made only limited changes to it. And only some of these changes are direct. Most of the changes have been indirect, such as through the enactment of special laws that override the code provisions for specified crimes. And more recently, there have been several decisions of the Constitutional Court, which many would argue have changed the code. In our chapter, we talk about the criminal code. And a couple of years ago, of course, it looked like one of these drafts might be adopted. But as has happened before, enactment didn't occur and the draft appears to have been largely dropped from the legislative agenda, at least for now. It might be revived again, but in the form that we examine in our chapter, the draft seems to have just too many issues that are too contentious for too many groups. So, for example, provisions on homosexuality and adultery might pit religious groups against others. Provisions on freedom of expression and freedom of the press might pit many of those in government and their backers against those who seek to retain or strengthen Indonesian democracy and human rights. Even if politicians themselves can reach common ground or negotiate deals between themselves, the public might not support those deals, leading to criticism and protest. And some would argue that it was protests such as these that appeared to have played a role in the decision of the legislature not to proceed with the bill a couple of years ago. Now, the Code of Criminal Procedure is, of course, much younger. As Tim said, it was enacted during the Suharto period. It was widely heralded as an improvement on its predecessor, which did not provide much in terms of rights for suspects and defendants, for example. But this code, I think it's fair to say, has not dated well, or an enabler of countless unfair trials and probably wrongful convictions in Indonesia. And here I think it's important to point out that we're not just talking about good or good enough laws being ignored or applied badly by law enforcement institutions. There are, of course, credible accounts of just this happening, such as when defendants are not afforded their rights to legal counsel during police interviews, for example. Now, I think it's fair to say that the Criminal Procedural Code itself is just as big a problem. It's very vaguely worded and incomplete. It doesn't provide penalties for law enforcement authorities that are found to have violated the rights of suspects and defendants, for example. And this, as many people have written, makes officers almost completely immune from any consequences of, for example, making it longer than is legally permitted. We discuss some of the shortcomings of the code and its enforcement in the chapter on the Code of Criminal Procedure, as well as some of the attempts to reform it. Things like introducing investigating judges, for example. But now, having given an overview, a very brief overview of the chapters, I wanted to highlight some things that I think are broad problems in the Indonesian justice system that I'm not sure can be addressed by amending either the Code of Criminal Procedure or the Criminal Code. And the first thing I want to highlight today is, and I've got two points to make here, is what I think may be an increasing trend in Indonesia, that is for Indonesian judges to ignore key defense evidence in many high-profile cases. On many of the cases that I've been reading and writing about, judges seem to have been much more receptive to prosecution evidence, even when there are really very serious problems with that evidence. There are lots of cases I could talk about in this context, all of which would be very familiar to an Indonesian audience, especially a legal audience such as we have today. I'm thinking of the Ahok case, where the former governor of Jakarta was convicted for blasphemy on the basis of a video that was doctored by someone later convicted for doctoring it. This case is discussed in one of the chapters of the book, Dan Peterson's chapter. The Jessica Wongso case, very controversial and high-profile case, but I think looking at it from an objective perspective, we have a person found guilty of murder, even though there was not even any hard evidence about the cause of death. When I say not hard evidence, I mean evidence that I don't think could really be sustained on a rigorous kind of examination of it, which I think the courts did not do in Indonesia. We also have the Jakarta International School case, where a school employee from Canada was found guilty of sexual assault of a minor based on very problematic and not very strong evidence. The problem is that when these defendants try to appeal on the basis that their evidence and arguments were not addressed, the appeal courts often say there was no error in the application of the law by the lower court, thereby ignoring the merits of the appeal. And reading these cases, you wonder what were the real reasons for the convictions. Unfortunately, one is led to potentially the conclusion that bribery or politics might have determined the outcome instead. That, or perhaps judges fear being perceived as being too soft, particularly after a long trial, and so feel compelled to find defendants guilty, perhaps also due to media pressure. Whether you think these people are guilty or not, I think is really beside the point. What I'm talking about here are components of a fair trial, including, of course, an impartial judicial process that determines your guilt or innocence based on evidence and legal arguments. The second area, which I think is problematic, and this is a new area of interest for me, something I've been doing some research about recently, is the use of expert legal witnesses in trials. Now, in many countries around the world, experts are simply not permitted to give an opinion about the content of the law at trial, and are certainly very strongly prohibited from explaining in any evidence how they think the law should be applied in a given case. This is widely considered by many countries to be the sole job of a court. But in Indonesia, I think increasingly evidence is being given by experts almost as a matter of course in almost all cases where parties have enough money to call their witnesses, or call witnesses to support their case. And I must admit to being a bit confused, scratching my head as to why they might do this. And I'd be very interested in any views that people might have. Perhaps we can discuss in the question and answer session later today. I think that when expert witnesses give evidence about the content of the law and how judges should apply it in a given case, I think it's a pretty bad look, and it raises questions particularly about judicial independence and judicial competence in Indonesia. And these are some of the questions that I'm trying to answer, which I think are not answered yet in any scholarly literature or in practice in Indonesia. One is, if judges are formally required to know the law, then why do they need expert witnesses to explain the law to them? I'm not talking about other types of expert testimony, things like scientific evidence, for example, or medical evidence. Here I'm talking about evidence about the content of the law. And why would a competent lawyer need to call an expert to explain the law to a judge if the lawyer, him or herself, could do this? Do experts really help lawyers convey the substance of their arguments? Or is the main purpose of the expert testimony to use the reputation of the expert to cause the judge to side with the party that called the expert, regardless of the merits of the case? And if this is true, then are we witnessing the privatization of justice in Indonesia, given that parties tend to pay very well-known experts a lot of money in order to testify? And similarly, does this thereby constitute a violation, I should say, of judicial independence? In many cases that I've read so far, legal experts provide information that judges must already know. In that context, they read sometimes a bit like the first lecture you might expect to receive at university in criminal law. in this context, I wonder whether it's possible to view expert legal evidence as a variety of doctrine, which of course in Indonesia is accepted by many as a secondary source of law. On this view, the expert testimony of a legal scholar may be really just the legal scholar's regurgitation or extension of their writings, which judges could otherwise access. And bringing them into the courtroom to opine on the relevant law might simply be seen as a more engaging way of conveying the doctrine to the court. Another possibility, I suppose, is whether expert evidence in Indonesia has evolved to fill a gap left by Indonesian not having a jury system. Is the expert providing the outsider perspective that a jury might otherwise provide? Now, of course, there are lots of problems with this analysis. Many other civil law countries don't have juries too. Also, don't they make decisions about facts, but experts in Indonesia, legal experts in Indonesia, sometimes do this too. Now, I'm generally baffled by why there's so many experts are called, because experts' views are actually quite rarely heeded by judges, at least in the cases that I've read so far. I'm hoping that one day these questions might be answered, perhaps in the second edition of the book. Tim and Helen, I just wanted to finish by congratulating you on producing such a wonderful volume. In my view, it's perhaps the most important scholarly contribution on the Indonesian criminal justice system. And I just wish that I had the idea first. Thank you.
Thank you very much, Simon. I really enjoyed the presentation, Simon. Thank you. And for the audience who speak Indonesian, don't worry. We will have several presenters who will give their presentation in Bahasa Indonesia later, such as Rifki and also Mbak Josie and Pak Topo later on today. And I think we just carry on to our next theme about crime reform and the court. We also have 3 chapters in this book regarding this theme. And on this occasion, we are very proud to have Mr. Tim Mann from Chili's, the University of Melbourne, and Dr. Absaree Devi from the Attorney General Office of the Republic of Indonesia, or Kejaksaan Agung. Good morning, Tim and Mbak Devi. I hope you already joined us today. I hope you both are well. Tim will present first for this panel. Tim Mann is the editor of the Indonesia at Melbourne blog. For those who are familiar with Indonesia at Melbourne, you probably can send your writings to Tim later. He is also the associate director of the Center of the CILIS, or Center for Indonesian Law, Islam and Society, and PhD candidate at the Melbourne Law School. Before joining CILIS, Tim worked as a program officer at the Asia Foundation in Jakarta. And this time, Tim will present his writing on pre-trial hearings, safeguarding human rights, or a gift for corruptors. Tim, we are happy to invite you. You have approximately 10 minutes, and please, the time is yours.
Okay. Terima kasih, Mbak Lilis. Before I begin, I'd just like to acknowledge that I'm speaking today from the land of the Wurundjeri people of the Kulin Nations. I'd like to pay my respect to their elders past, present and emerging, and recognize that sovereignty was never ceded. So as Lilis said, my presentation today is on pre-trial hearings, and I wanted to start with a photo that I think would be familiar to everybody here of the former Speaker of the DPR and the former Golkar Chairman Setia Novanto. In July 2017, the Corruption Eradication Commission, or KPK, named him a suspect in one of the largest corruption scandals in Indonesian history, the 2.3 trillion rupiah electronic identity card case. And in September of that year, you'll probably remember that he successfully challenged his suspect status in a pretrial hearing, or pra-peradilan. And this followed, it came on the back of a series of corruption suspects using pretrial hearings as a means to evade charges. And despite the apparently serious nature of his condition here, just a few days after he won his pretrial hearing, he was discharged from hospital. Of course, when he was named a suspect by the KPK for a second time, he then staged a car accident, leading to internet users having a lot of fun with the Save Tiang Listrik hashtag, and then was eventually sentenced to 15 years in prison. I want to leave Setnov there for now. I go into his case in quite a bit of detail in my chapter, but today I thought I just would like to focus a bit more on the pretrial hearing process that saw him momentarily escape charges. Sorry, let me just, there we go. So the pretrial mechanism was introduced with the passage of the Criminal Procedure Code, or KUHP, in 1981. And as Simon mentioned, at the time, it was considered a major advance from the Dutch Colonial Procedure Code that it replaced, the HIR. The HIR had allowed suspects to be detained, sometimes for up to years at a time, with no legal recourse to challenge their detention. So the introduction of the KUHP was therefore intended to provide a better balance between the needs of law enforcement officials to arrest and detain people and the rights of the accused. The KUHP authorises district courts to hear pretrial proceedings on three matters: the legality of arrest or detention, the legality of the termination of an investigation or prosecution, and request for compensation or rehabilitation if a case does not progress to trial. And this is outlined under Article 1.10 and 77 of the KUHP. Excuse me. Pretrial hearings are heard by a single judge, and a decision must be handed down within 7 days. Decisions in pretrial hearings cannot be appealed, and as such, they're highly vulnerable to the whims of the deciding judge and quite notorious for a lack of uniformity and predictability. One of the fundamental weaknesses with the process is that applications for pretrial hearings can obviously only be made after the arrest and detention has occurred. Investigators are not obliged to prove to a court that their actions in arresting or detaining a person are justified unless the suspect or accused files a pretrial motion. So this leaves a lot of room for abuse of power by investigators and creates incentives for officials to deny access to legal counsel. As you can imagine, they are also only typically filed by wealthier defendants who have the resources to launch a challenge. But I want to continue to highlight one particular aspect, and that is suspect status as a matter that can be challenged. So the nature of pretrial hearings changed quite dramatically in early 2015. You will probably all remember that in early 2015, when Jokowi had just begun his first term, he selected Budi Gunawan as his preferred candidate for police chief. And almost immediately after Gunawan's name was announced on 13th of January, the KPK named Gunawan a suspect for corruption. On the 19th of January, Gunawan submitted a pretrial application at the South Jakarta District Court. And around a month later, on the 16th of February, the judge hearing the case made the surprising decision that Gunawan's suspect status was illegal. This went beyond the remit of pretrial hearings as described under Article 77 of the KUHP. And it was one of the first times that the scope of pretrial hearings had been interpreted as extending to the naming of suspects. There was actually a previous case in 2012, but the decision was eventually overturned and the judge who made that decision received an ethical sanction. In any case, there were immediate concerns that following the 2015 decision, this would encourage other alleged corruptors to follow in Gunawan's footsteps and challenge their suspect status. And a few months later, on the 28th of April, the Constitutional Court made sure that this would be the case. The court ruled that Article 77 of the KUHAP, 77A, excuse me, was unconstitutional unless it was interpreted to extend to the naming of suspects, as well as body or property searches and seizure of goods or property. The court argued that naming someone a suspect involved a restriction of rights or freedoms, and so it was necessary to provide the accused with a mechanism to challenge abuses of power. Reading the decision, it does seem as though the motivation of the court was to strengthen human rights protections for suspects. The decision noted that being named a suspect did not have a clear time limit, meaning that individuals were forced to accept their suspect status without any legal means to question the legality or purpose of being labelled as such. So the court argued that extending the scope of pretrial hearings to include suspect status was important to protect individuals from ill treatment by investigators. But just as anti-corruption activists feared, this opened the door for other alleged corruptors to challenge their suspect status. And the first came just a couple of weeks later with the former mayor of Makassar, who got off on a pretrial challenge in May of that year. This was followed by a range of other high-profile corruption suspects, and I'm not going to go into all of the details here now, but some of these have subsequently been arrested again and convicted, while others have continued to evade charges. Although this is a worrying trend, it is important to recognise that on balance, corruption suspects don't actually do so well in pretrial hearings, as this table shows. So before the Budi Gunawan decision, the KPK had actually never lost a pretrial challenge. This data here is based, it's only from the KPK's reports, so it doesn't include challenges lost by the prosecutor's office, for example. So one case that might fit into this category is the former Jepara district head, Ahmad Marzuki, who successfully challenged his suspect status in 2017. I also think it's probably worth mentioning that some of these challenges have related to the KPK dropping investigations. So the fact that the KPK did not lose any challenges in 2019, it's not necessarily a clear-cut win for corruption eradication. So just finally, I just wanted to finish up by looking at the prospects for reform. What chances are there for a better process? There's been discussions on reform of the KUHAP for almost as long as the KUHAP has existed. And many of the people presenting here today are much more involved in these discussions than I am. So they may be able to provide us a bit more of an update later on. But in the most recent version of the draft code, the RUU KUHAP that I have seen, there's a proposal to replace pretrial hearings with investigating judges or Hakim Pemeriksa Pendahuluan, who will have the authority to rule and decide on the legality of arrest, detention, search, seizure of goods, and the tapping of communications. Under the most recent draft, police, investigators, and prosecutors will only be able to detain individuals for up to 5 days before they have to bring them before an investigating judge, who can then decide whether detention should be extended. So this is a significant advance, but these reforms are likely to see significant pushback from police and prosecutors. It's also important to note that the RUU KUHAP is not on the priority list of bills for discussion in 2021, which I believe was finally decided on just yesterday. And given the glacial pace of reform on this and the related KUHP, it may be some time yet before there's any change to the pretrial process. I'll leave it there. Thank you, Mbak Lilis.
Thank you, Tim. Terima kasih. I think from the two first presentation, which is Simon and Tim, we can see there are many particularities in Indonesian criminal law and criminal justice system in practice, which makes the two codes, as Simon mentioned in his presentation, that the two codes, the criminal codes and the criminal procedures code, are really left very, very left behind. So I think this discussion is really timely to discuss to what extent that we can put reform to these two codes or to the criminal law and criminal justice system. Thank you very much, Tim, for the insightful presentation. I would like to further invite our third speaker, Dr. Absaree Devi. Mbak Devi has PhD from the University of Melbourne. She currently works at the Kejaksaan Agung and hold position as State Lawyer Coordinator, the Provincial Prosecutions Office of Jakarta. Mbak Devi's doctoral thesis examined the strengths and limitations of international extradition, with particular case of Indonesia and Australia. Mbak Devi, I will now give you the time to present. Please, Mbak Devi.
Dear moderator, Dr. Lilis Mulyani, a very dear friend of mine and a former fellow student, thank you for giving me the floor. I would like to begin this opportunity especially to extend my deepest gratitude and appreciation to the editors of Crime and Punishment in Indonesia's book, Bapak Professor Tim Lindsay, and also Dr. Helen Pausaker. Professor Tim Lindsay was my supervisor for my doctoral studies, and this chapter of the book that I'm going to present today is part of my 2018 PhD thesis at the University of Melbourne Law School. So my special thanks goes to Pak Tim. I also would like to thank the Center of Indonesian Law, Islam and Society, Melbourne Law School, the Indonesian Institute of Science, the Jentera School of Law, the Indonesian Institute of Independent Judiciary, Hukum Online, and all colleges in Indonesia and Australia who have organized this event. I'm going to begin this presentation by sharing with you two extradition cases to give you a better illustration of the state of extradition in Indonesia. The first case is extradition of Syed Abbas, a person requested for extradition by Australia to Indonesia for people smuggling offenses. Syed Abbas case was the longest extradition case that Indonesia has ever handled and involved a range of legal and non-legal obstacles that explain the long delay. Abbas' request was first submitted in 2010 for 13 offenses he committed in 2009. Abbas is wanted in Australia for his involvement in facilitating the bringing to Australia of a group of 5 people who had lawful right to come to Australia. Indonesian authority initially could not process this extradition request because at the time, Abbas faced a criminal legal proceeding in Indonesia. He was tried in Indonesia for violation of Indonesian immigration law, in that he arranged the departure of asylum seekers by boat to Australia. To cut a long story short, the Indonesian Supreme Court sentenced Abbas for 2 years and 6 months imprisonment in February 2011. And in February 2013, Australia sent the second extradition request regarding Syed Abbas for another 14 offenses of people smuggling. Despite the concern about whether the second extradition request from Australia would trigger the double jeopardy ground of refusal, Abbas was detained for his extradition process to respond to the Australian extradition request as soon as he finished serving his sentence for the criminal offense in Indonesia. His extradition case was heard in Jakarta District Court. However, in July 2013, the court issued an order stating that Abbas was not extraditable because the people smuggling offense did not appear in the list of offense in either the extradition treaty between Indonesia and Australia or the 1979 Indonesian extradition law. The court then ordered his release. To give you further illustration, at this time, the political bilateral relationship between Indonesia and Australia was in general good. In the second term of his presidency, Yudhoyono's foreign policy focused on Indonesian international reputation and his aim of 100 friends and 0 enemies. During this time, Indonesia often described Australia as its best friend. This was made clear when President Yudhoyono delivered a speech to a joint sitting of the Australian Parliament in March 2010. The two countries said were strategic partners that have a good future together. Good relationship was a real benefit for Australia, as prosecutors submitted an appeal to the High Court of Jakarta, even though Indonesian extradition law does not provide for an appeal from a district court order in an extradition case. Unfortunately, this enthusiasm to extradite Abbas to Australia disappeared after the spying incident of late 2013, when WikiLeaks revealed Australia had tapped the phone of President Yudhoyono and his inner circle. At the time, Yudhoyono was publicly urged to stop law enforcement cooperation with Australia entirely. Abbas' extradition was then awaiting appeal determination in an Indonesian High Court, which made it difficult to stop the process. The High Court finally ruled Abbas extraditable on the 23rd February 2014. When this ruling was handed down, the bilateral relationship had not fully recovered from the wiretap scandal. As a result, it took another year before government institutions actually began to take further steps in extradition process. It was not until May 2015, 1 year and 2 months after High Court decision to extradite, that the court determination and the necessary advisory letter of the relevant minister were submitted to the president for decision. It's worth noting that before this happened, the two countries had signed the Australia-Indonesia Joint Understanding on Code of Conduct in 2014, a requirement set by Yudhoyono for the resolution of the spying issues and the resumption of the normal relation. It took 5 years before Syed Abbas was extradited from Indonesia to Australia. Indonesia received the first request for its extradition in 2010, and he was only finally surrendered to Australia in August 2015. And in the second case, Italy, on the other hand, sent an extradition request to Indonesia for Antonino Messicate Vitale in 2012 for organized crime, extortion, and vandalism offenses. In Indonesia and Italy do not have a bilateral extradition treaty yet. Indonesia still processed the request anyway. It is important to note that an extradition request from a country to which Indonesia does not have a bilateral treaty requires 2 presidential decisions. First, the Indonesian president should decide that the extradition request can be processed. And second, a final presidential decision on the request itself is required. The first approval issued on 27 June 2030. The request was then processed by Indonesian police on the 21st August 2013. And after 1.5 months of extradition dossier was submitted to the prosecutor of the Provincial Prosecution Office of Bali. The prosecutor then submitted the case to the District Court in Denpasar in November 2013, and the extradition hearing took place in November 2013. The court ruled that Vitale was extraditable at the first hearing and the issued court order on the same day, on the 20th November of 2013. Exactly 12 days later, following the completion of various legal formalities, Vitale extradition to Italy was duly granted. Discrepancy in the extradition time frame in the two cases that I have present previously raised a question on how Indonesia processed extradition requests from foreign countries. Abbas was requested by Australia, while Vitale was requested by Italy. It took a little over 5 years for Indonesia to surrender Abbas to Australia, and interestingly, Vitale was